A separation agreement is a legally binding contract between two married people who are contemplating divorce or waiting to get divorced. While a separation agreement is not required in Virginia, there are many good reasons to have one. In Virginia, you must be separated for 1 full year before you can be divorced, unless you have a separation agreement. If you have a separation agreement and no children, you can reduce the waiting period for a divorce down from 1 year to 6 months. A separation agreement can greatly reduce the time and cost of a divorce by addressing important issues such as child support, custody, spousal support, division of assets, and retirement. Rather than spending thousands of dollars on attorney's fees going to court to have a judge decide these issues, the parties can enter into a separation agreement and skip the long and expensive process of a contested divorce. In most cases, a separation agreement is a permanent and final document that is filed with the court and ultimately becomes a court order. Once it is a court order, if a party violates the terms, that person can be held in contempt of court and in some cases fined and even imprisoned. Usually, if you sign a separation agreement, that is the entire agreement between you and your spouse, and you will not have the opportunity to change the terms of the agreement. Therefore, you should never sign a separation agreement unless your attorney has first reviewed it. You may be waiving your rights to a valuable asset simply because it was not mentioned in the separation agreement. If you own a house, it should be included in the separation agreement. The agreement should cover who gets the house, or if it is sold, how the profits or losses should be divided, who makes the mortgage payments while waiting for a sale, and if the house doesn't sell, who gets it and who pays for it. The agreement should also cover issues while the divorce is pending. Who makes the mortgage payments pending the divorce? Who keeps up the lawn and maintenance? Also, debt can be divided in a separation agreement. But the separation agreement is between you and your spouse. Your creditors are not party to the separation agreement. If your spouse agrees to pay a debt in the separation agreement and then fails to do so, you are still liable to the creditor. The creditor may sue you for the money. Because your separation agreement is a legally binding contract, you may then look to your former spouse for breach of contract. Many financial obligations listed in a separation agreement become non-dischargeable in bankruptcy. So, before you agree to spousal support or other similar financial obligations, remember, you may not be able to file bankruptcy against them later. If either you or your spouse are in the military, your agreement should address military retirement. Typically, if you've been married for over 10 years, the DFAS will honor a separation agreement that was incorporated into a final decree of divorce and cut the check directly from DFAS to the military spouse. If you have been married for under 10 years, DFAS will not issue a direct payment, but the spouse may still be entitled to receive a portion of the military retirement, but it would be paid directly by the service member. DFAS will not direct pay military retirement to a former military spouse unless there is a court order stating the former military spouse is entitled. If you are a military spouse and you sign an agreement that does not give you military retirement, or enter into an uncontested divorce that does not order military retirement, then you most likely will be barred from receiving military retirement. Bottom line, if you think you may be entitled to military retirement, you should not sign any divorce documents without having an attorney review them first. The most important thing to remember about a separation agreement is that in most cases they become a permanent court order and you'll have no further opportunity to change or add to it. You should make sure that you fully review it before you sign it. Ask yourself, how will this affect me 10 or 20 years from now? Make sure you get everything you want written down into the agreement before you sign it. One of the very few things you can go back and change in a separation agreement is child support and custody, based on a showing of changed circumstances and best interest of the child. However, if your separation agreement waives marital assets, pensions, retirements, spousal support, or equity in a home, you generally have no opportunity to change your mind. You should always consult an attorney before signing a separation agreement because you might be waiving your rights and not even know it. If you're in the process of getting a divorce or are going through a marital separation, please call the attorneys at John W. Lee PC.